audio?
Nope.
Come on.
Good morning, ladies and gentlemen. Welcome to Bexar County County Court of Law number 6 and the Bexar County Veterans Treatment Court. Today is MTR docket day, September 23rd, 2021, approximately 10:20 a.m. The cases on my docket for today are cause number 642-530, State of Texas versus Juan Guerra Mendez, represented by Mr. Ed Bartolome. Cause number 6544435, State of Texas versus Ashley Guerrero, represented by Ms. Linda Corley. Cause number 660412, State of Texas versus Jacob Moya, represented by Mr. Michael Bellevue. Cause number 571024, State of Texas versus Talia Heron, represented by Mr. Junius Hicks. Cause number 612208, State of Texas versus Christopher Collins, represented by Mr. Aldous Strouch. Cause number 657492, State of Texas versus Cedric Sanchez, represented by Mr. Sean Farmer. And cause number 639519, State of Texas versus Juan Portillo, represented by Mr. Raymond Martinez. Originally, we had Mr. Jimmy Garcia, 625249. My understanding is he has come down with a plague or something, and unfortunately, is that correct?
Yes, Your Honor.
Representing the state are going to be Ms. Megan Galloway and Mr. Guillermo Flores. Representing the Bexar County CSC is Ms. Susan Gross, who I will swear at this time. Please raise your right hand. Do you swear the testimony you are about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Are we
Your
ready?
Honor,
Go ahead.
Your Honor, just to let you know, right now, we do not have an interpreter. They are all in other courts. So as soon as they come in, then we will deal with it. And also the person who needs the interpreter at this point does not have audio. They're trying to get him to do it now, just so that you know.
What cases are we ready on right now?
Mr. Martinez's, Mr. Farmer's, and then and Mr. Hicks, and on Jacob Moya, again, they want to get together with you in a breakout room.
Okay, Mr. Hicks, are you ready to proceed on Ms. Heron's case 571024?
Yes,
Let's start with that one.
yes, Judge. Yes, Judge, I am.
Thank you, sir.
You're welcome.
This is cause 571024, State of Texas versus Talia Heron. This is a motion to enter adjudication of guilt and revoke community supervision. And as previously stated, representing Ms. Heron is Mr. Junius Hicks. The first document I need each of you to identify your signature on is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Ms. Heron, is this your signature on this document, ma'am?
Yes, sir.
Thank you. And Mr. Hicks, as attorney for Ms. Heron, is this also your signature on this document?
It is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal. And Ms. Heron, is this your signature on this document also, ma'am?
Yes, sir.
And Mr. Hicks, as attorney for Ms. Heron, is this also your signature on this document?
It is, Your Honor.
Thank you. And Mr. Hicks, my understanding is this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that accurate?
It is, Your Honor.
Fair enough. Ms. Heron, in cause 571024 on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, ma'am?
True.
And Ms. Gross, would you please advise the court and the parties of the status of Ms. Heron's probation, please?
Yes, Your Honor. Since being placed on probation, her reporting has been fair. She's skipped a total of 2 months of reporting. We last saw her September 15th of 2021. Her case is paid in full. Her community service is completed. She has had 11 negative drug tests. She has completed DWI education, victim impact panel, the CAT-SNP program, and she has been submitting to weekly drug testing since August 11th of 2021 and has had no reported issues. She is currently on Smart Start Mobile testing 6 times per day. She has had 11 skips as alleged on the MTR, and since then, she has had 3 additional skips. This is her third motion to revoke, her second that's actually been heard. She has a prior arrest for possession of marijuana 0 to 2 ounces. The officer's recommendation is that she be continued on probation and that she maintain a Smart Start device until she is off probation.
Okay, Mr. Hicks, here's my issue, and I'm going to ask you to respond to that. I can't get Miss Heron to blow in the machine, I guess is part of the problem right now, which means the only real option I have left is either a scram bracelet or revocation. Now she's got 70, Pat, is this correct? 77 days credit for jail credit?
Yes, Your Honor.
So Mr. Hicks, one of your options, she's done everything else. I just can't get her to use the machine properly. It's kind of where we're at now. This is her third MTR. Here's my 2 options. A, if she'll volunteer for scram, because it's going to cost $350 a month, I'll continue her on deferred adjudication probation and deny the MTR. If she'd rather be revoked, I'll revoke her. I'm going to find her guilty of the offense of DWI, and I'm going to sentence her to 180 days in jail credit for time served, judgment satisfied. So those are your 2 options. Would you like to go talk to her in a breakout room and see what y'all would like to do on that?
Your Honor, we've talked extensively on this, and I'd like to speak to you,
Sure,
if I can, regarding the explanation.
sure.
Your Honor, since the last time that since October, August the 30th, as of yesterday, when I spoke with the supervising probation officer, she's had no skips at all. Since that last skip, which was on August the 30th at 3 p.m., she's gone back, had the device retested the very next day. She's been retrained on the device, and since then, she's had absolutely no skips at all, notwithstanding the fact that she's now quarantined for coronavirus. So she's tried everything. It appeared that most of those prior skips were early in the morning or late at night. She has a toddler. She's a full-time student. She works full-time, but as I indicated, after she realized that something was wrong with the device, she went the very next day. She went the same day. They tested the device and said that it was okay. She went back the very next day and got retrained. So she's attempting to do all that she can. However, she's financially strapped at this time, Your Honor. For one, she has coronavirus. She's been quarantined for 10 to 15 days. I'm not sure whether or not her child has gotten the coronavirus. Not, will you shake your head one way or another, Miss Harry?
No, he
I
doesn't.
guess she can't hear. So at any rate, she'd like to explain to you where she fell short, which was trying to operate that device correctly. And she can't use the device at her job. They have told her that it's off limit. You can't bring any device of that nature to her job. And so she's attempted in good faith to do everything. She is scrapped for money. She's not able to go to any other device. What my recommendation is, if you, with all due respect, is that you give her another month, or if she has no skips, then reduce it back down to the 4. She's paid everything. She's done everything. It's just a matter of her operating that device incorrectly, and she was having some issues with sleep deprivity due to, I guess, the coronavirus, and the onset of that disease was coming on her. And like I said, they were all early in the morning or late at night, with the exception of, I think, 3 instances in the afternoon. She has corrected all those as of my conversation with the probation supervisor yesterday evening. He showed no additional skips since the retraining. That's it, except she scrapped for cash, but she did pay all of her fees and all of that. And she's coming out of the coronavirus, but she's suffered through the coronavirus and she's been retrained. I have every confidence that my client will make it for an additional month at the CC6 per days. And then if you were quite happy.
Okay, Mr. Hicks, if I may, confirm for me, the reason she missed these 11 skips is because she slept through them primarily, or they were late at night and she went to bed early and slept through them? Is that kind of the reason why we missed these skips?
Due to her toddler and all of, yes, the answer is yes.
And then the next question I have is, what is her job where you're telling me that she can't use the Smart Start mobile device at her job?
Can she answer that?
Sure, of course. Ms. Herron, where are you working, ma'am?
I work at a call center. It's called Conduent. They have a clean desk policy.
Okay. My understanding is you get 2-hour window to blow each time you have to blow in this machine. Why can't you just go into the ladies' room and blow in the machine and come back?
Yes, sir. I can. I already spoke to, after I got the 11 missed or violations, I spoke to my supervisor at work and let them know about the device so that I have time to be able to clock out and then go do the device. So there won't be any issues with that anymore.
Ms. Gross, can you advise the court and the parties of what the basis for the first MTR on Ms. Herron and the second MTR on Ms. Herron was? Did we have skips back then too, or was it some other issue? Because she's apparently done everything else. Our only real problem right now is the device skips. Is that accurate?
Yes, Your Honor. Give me just one moment. I'm pulling up the original MTR. The original MTR was because she failed to go and sign her conditions. She didn't go to orientation. And then we amended it to add a new DWI and alcohol consumption. And then the second MTR that was filed, give me just one moment. Then the second MTR that was filed, it alleged that she had failed to do her community service. She had skipped 5 tests and had not done her CAT-SNP class. And at the time that that MTR was filed, during her term of probation, she had missed a total of 8 tests. And that MTR was not heard. You gave her the opportunity to redeem herself by being admonished and educated about skip tests, and that she had to provide proof of her enrollment in CAT-SNP within 10 days. So she has been educated prior to this about skip tests and the importance of making her blows on time. And we were here just a month ago and you gave her yet another opportunity. And here we are again.
You mentioned a second DWI. What was that dismissed? What's the status of that?
Give me 1 second, Your Honor. I believe that one was out of county, Your Honor. Let me double check.
Mr. Hicks, are you aware of a second DWI that Ms. Heron has somewhere?
No, Your Honor.
Ms. Hicks, excuse me, Ms. Heron, do you have a second DWI somewhere?
No, sir. This is my first
That's
DWI.
why, that's why I'm confused. I'm sure Mr. Hicks is confused. I haven't heard about this one before. We need to get to the bottom of that.
It looks like it was April 17th of 2018.
In what county?
Bear.
And that, is there a cause number on that one?
Cause number, actually, it's the same as this one, so I'm not sure how that ended up on the motion. Because the motion said, yes, it reflects the date of this particular offense.
All right, so it's a mistake. Well, there's only one DWI we're dealing with. Do you agree?
Correct.
All right. All good. State recommendation, please.
Your Honor, we recommend that she be continued, that she be placed on SCRAM, and that she continue with her weekly raise.
Okay, so you're recommending that she be continued, is that correct?
That's correct, Your Honor.
All right. Hey, Mr. Bartolome, I'm gonna call you in as my expert. On a deferred adjudication, Ed, if you terminate it unsat, she doesn't get a conviction for DWI. What's the ultimate effect of just an unsat off of a probation on a deferred adjudication on DWI?
My understanding is, Your Honor, that she would not have a conviction. It would just be unsatisfactorily completed. And that's controversial, to say the least. And I don't mean that negatively, Judge.
I understand.
You know what I'm saying? It shows up unsat. That's all it shows.
I'm trying to craft a sentence or a structure, a response to this MTR that gives her credit for all the things she's done correctly. But on the other hand, I mean, this is Lacey a third MTR. Mr. Hicks, what would be the defense position if I were just to agree to terminate Ms. Heron's deferred adjudication probation unsatisfactorily? I wouldn't revoke her. I wouldn't find her guilty of DWI. She would just be termed unsatisfactorily. Is that something that you think the defense would find equitable under the circumstances?
That's what she's interested in, due to trying to graduate, stay in school full time, deal with a toddler, deal with the coronavirus. My concern is that if we take that approach, will she be unable to get scholarships? She's trying to become in the legal system herself. Will she be denied scholarships in the future? Ed?
Yeah.
I don't have an answer for that because I'm not aware of how all that works, but she would not technically have a conviction under the Texas state law, best I can tell, for DWI. It would just be terminated unsatisfactory as far as her probation goes. I would not be revoking her deferred adjudication formally and finding her guilty of DWI. I would just be terminating her deferred adjudication probation unsatisfactorily. State, Megan, do you have a feel for what the ultimate impact of something like that would be?
Judge, I believe that would just close the case and terminate the community supervision.
Ms. Gross, do you have a feel for what the impact? We've done this before, but I just don't know what the ultimate impact on the defendant would be.
Judge, I'm not sure what the outcome would be in regards to her applying for scholarships or jobs down the road. I don't know.
Well,
Mr. Martinez, you're my other expert. Ray, have you ever run into this before?
Judge, I've always told my clients that as long as the court never adjudicated you guilty, you don't have a conviction, and therefore you could apply for non-disclosure. Now, whether the state opposes it or not, that's a different question. I don't know whether they would or not in that situation.
All right, Mr. Hicks, here's my plan. What I'm going to do is deny the state's motion and order that Ms. Heron's probation be terminated unsatisfactorily. I have 30
Yes.
days jurisdiction on this case for you to look into the scholarship aspect of it or look into any other impact it may or may not have on her. I don't think it's going to bother her in regard to scholarship because she'll have to say I was arrested on this date and no conviction or something. It's because it's not still pending. The case will be over. But you're
breaking up on me, Judge.
Yes, sir.
But I have discussed this situation with Ms. Herron, and she has agreed if you would terminate her unsatisfactorily, that she's in agreement with that. Is that correct, Ms. Herron?
Yes.
Okay. You've already served a long time in jail on this. You've already paid the price on all this stuff. State, is that okay with you?
No objection, Your Honor.
Okay. Ms. Herron, in cause 571-024, the court denies the state's motion to enter adjudication of guilt and revoke community supervision and orders your probation terminated unsatisfactorily. Anything further from the state or the defense on Ms. Herron?
Judge,
Nothing more.
Good luck, Ms.
Nothing.
Herron. And Mr. Hicks, get back to me within 30 days if there's something else we need to do to help her, okay?
Judge,
Okay.
Yeah.
I just need you to notate that this is an early termination because she's not off probation yet. She doesn't expire until November 3rd.
Well, then just terminate.
Oh, boy, you're bringing the law into it. That's going to muck it all
Yeah.
up.
Can you do an early for a DWI? I believe you can't, not.
Nope,
I don't think so.
that's true.
I think she's stuck with this, John, until November.
All right. All right. I hate it when Susan comes up with a law that really, slowed me down. All right,
Sorry,
Ms. Herron, I tried it that way. That's not going to work. Let me try it again. Ms. Herron, in cause 571-024, the court denies the state's motion to enter adjudication of guilt and revoke community supervision, orders you continued on deferred adjudication probation with no sanction at this time, altering amending conditions, waiving weekly UAs, continuing the Smart Start mobile device at 6 blows a day. I'm giving you fair warning. This is your last chance. You can't miss any more tests, okay? That's really our only major issue that I'm aware of. Susan, is there anything else we need to brief Ms. Herron on at this time, or is that it?
I have a question.
Yes, ma'am. Go ahead.
As far as one of the blows at 4 a.m, is it a way that my probation officer can move that time to say like 6 a.m?
Well, if you're on 6 blows a day, there's only so much time in the day. And the reason
You
you're
have
on 6 blows a day, yes, ma'am, go ahead.
Oh, I was going to say, you have a 2-hour window. So you're just going to have to set an alarm and make it work.
Okay.
Now, Ms. Herron, if you show me 30 days period of time where you haven't missed any blows and there are no high brags for alcohol, I'll crank you back down to 4 blows. That could be 31 days from right now, okay?
Okay.
You're gonna have to get a couple of alarm clocks and get them working and just stay with me. That's the best I can do for you.
All right. Thank you.
All right, Mr. Hicks, anything further?
Nothing further, Your Honor. So I will need to come back for another hearing in about 30 days.
Well, no, you just need to text me or text Pat and let us know.
Or just wait
Ms.
until
Herron has done,
November.
yeah, I won't know if she's done that. She needs to let you know. You just let me know. We don't need a hearing on it. I'll confirm through Ms. Gross at probation. And if she's done it, then I just tell Ms. Gross to alter and amend and crank her back down to 4. No big deal.
Interpreters.
Okay.
All right.
Thank you, Your Honor.
All right. And Ms. Herron, you're doing a great job except for the skipping stuff.
Is when
fix
the
that and we're
10-minute
good.
finishes.
Thank you.
Ms.
Yes.
Herron,
And Your Honor,
you need to touch base with your
let me ask
officer
report
and let her know
what's
that
through
you
the
were in
super-
court today and what happened.
Hey, everybody
Okay?
stop talking, please.
Okay.
Susan, go ahead.
the supervisor, the probation.
Mr. Hicks, hang on just a second. Susan, go ahead.
Okay, Ms. Herron, touch base with your officer, let her know what happened today, and I'll be making my notes later this afternoon. But you can just let her know that you are no longer going to be doing weekly drug testing. But as far as that in your machine, your times and the number of times that you're going to blow are going to remain the same. Go get yourself a second alarm clock or something, because otherwise you're going to be right back here in a month, okay?
All right. Thank you.
She's only
All
got,
right,
what,
good luck
2 more
to you.
months on her probation to begin with?
Yes, she expires on November 3rd, Your Honor.
All right. Hang in there. You're gonna make it, Miss Heron.
Okay, thank you.
Thank you, Mr. Hicks. Do you have anything else? Your microphone's turned off, Mr. Hicks. Mr. Hicks, you're talking, but your microphone's turned off. Your
Yeah.
microphone's still turned off, Mr. Hicks. Gotta turn your mic. There you go.
Okay, Your Honor, all I could get was up to date to September, early September. The supervising probation officer yesterday afternoon told me that Ms. Gross could tell me if there's any skips since August the 30th, which is when she was retrained.
If she's got a 30-day period of time, even in the past between when I put her on 6 blows a day and right now, that we didn't have any missed tests and we didn't have any hyperacts or alcohol, I'll honor that. I just don't know if that's happened or not.
And yes, Mr. Hicks, she's had 3 skips since August 30th.
What dates were those, please?
September 13, September 14, and September 16.
And the 13th, what time?
This isn't the time or the place for this. We have cases that we need to get to. You
Ms.
can
Gross,
reach out to the officer.
I spoke with the supervising probation officer yesterday, and he gave me everything up to yesterday. He said you could tell me this morning of what times. 9:30. As of yesterday at 4 o'clock, he said there were no skips after August the 30th at 3 p.m. So you're now telling me September 13th, 14th, and 16th.
Yes, on the 13th, she skipped a test at 6 o'clock in the morning.
Okay.
On the 14th, she skipped a test at 4 o'clock in the afternoon. And then on the 16th, she skipped a test at 1 o'clock in the morning.
Okay. Thank you, Ms. Gross.
You're
Judge
welcome.
Christian,
Yes, sir.
Christian, I've
Yes,
seen where she's done decently since she became aware of those skips. So since she had 11 up to August the 30th, she was retrained. And after that, she's had only 3 skips, one early in the morning at 6 a.m., and then 4 p.m., and then 1 a.m. During that period of time, she's quarantined and suffering with the coronavirus and with the toddler, still trying to work and still trying to go to school. So she's made quite an improvement. And I just wanted that point to be made to you that she's making every effort or made quite an improvement since the 11 skips up to August the 30th. Since then, 3 skips early in the morning, 6 a.m. and 1 a.m. Under the coronavirus. She may not look sick now, but she, so I wanted you to be aware of the fact that she's made quite an effort, as I have.
I understand. I have a question for Susan. Susan, what is the last day that Miss Heron had a skip?
It was on September 16th.
Okay, well, I'm not helping you. She can start getting credit for September 17th. Obviously, today is the 23rd, but that time will count for her not having any skips and not having any high brack. So you show me 30 days, we'll crank her back down to 4.
Okay, and that 9/16 judge was at 1 a.m. in the morning. She has a toddler. And she's in coronavirus plus a toddler. She's fighting for her life, Your Honor. But she wants her career, future life to be better.
Ms. Heron, do you have any further questions, ma'am? We're going to cut you loose here in a second. Your microphone's on, ma'am. I'm off, rather, excuse me.
Sorry. Can we start it off from today instead of the 17th?
Of course.
Is that possible?
Of course.
Thank you.
I'm just giving you credit for like an extra week or so. But that, you and your lawyer can talk about that. That's not a problem. Just show me 30 days without missing any blows and no hybrax for alcohol, and I'll crank you back down to 4. If that happens, let your lawyer know. He lets me know. I confirm with Susan and I just call it in. Okay?
All right. Thank you.
Thank you, ma'am. Thank you, Mr. Hicks.
Thank you, Judge Christian.
Y'all are excused.
Thank you.
Your Honor, we have the interpreter now,
Oh, good.
but we have not set up with Mr. Guerra.
Okay. How long will it take to set up with Mr. Guerra?
I don't know if the interpreter, Norma Stas, are you there? Norma, she may be in an,
No, yes,
There
I
she is.
am. I was just answering another interpreter call because
sure. We need to try to set up Mr. Guerra. What do we need to do?
I mean, I already got the invitation with the interpretation function. Is he in custody or is he?
No, he's right above you in the Zoom. Antonio Guerra.
Señor Guerra, ¿me escucha? Señor Guerra, ¿me escucha? He's not responding.
Right, okay, now.
Ahí estoy,
Señor Guerra, ok,
¿Cómo está,
perfecto.
señor?
ahí estoy.
Ok,
¿Sí me escucha?
Sí, me escucha.
Sí, sí le
Ok.
escucho.
Le voy a pedir que en su teléfono, le voy a dar unas instrucciones. En su teléfono, toque la pantalla y le van a aparecer 3 puntos.
Pat, I'm taking a 2-minute break while you get this figured out. Thank you.
Ok,
Van a aparecer 3 puntos y usted le va a salir la opción de interpretación o lenguaje.
ok,
Seleccione español,
ok,
¿ok? ¿Ya lo
Ajá.
seleccionó?
ya. Le pongo listo. Le pongo listo, ¿ah? Sí,
Okay.
Thank you.
sí, sí le escucho. Ahí estoy en español. Ok,
Okay, I believe all of us
ok.
have hit English, hit interpretation, and then hit English. I can. Edward Bartholomew.
Yes, ma'am. I'm here. Yo estoy aquí, pero inglés o español por mí. I'm here. What do I have to hit? Chat, screen, share, interpretación. Inglés por mí.
Okay,
Yes, ma'am.
and we cannot hear you, Mr. Bartholomew. You need to speak louder.
All right. In English for me, is that correct?
You're good. Yes,
Thank
you're
you.
great.
Gracias.
And I don't know whether the judge stepped away or he's ready or what.
All right. Can I talk while we have Mr. Guerra on the phone? Mr. Guerra,
Sí,
ask the interpreter. It's importante por usted diga sí o no, not sí. Okay? Tell him to answer the questions directly, not yes. One way or the other. Comprende?
¿cómo? Ok, sí,
And tell him to listen and just
Gracias.
relax. And good morning. Thank you, Ben.
Okay. Mr. Flores, I'm gonna put you in with Mr. Strauss in a breakout room so that y'all can confer.
Thank you.
Pat, Guillermo stepped out really quick. But you
Okay.
can just put them in there and I'll tell him to go in.
Okay, okay. He needs to go back into 2. And then I'll put Mr. Strauss in 2. He can wait for him.
Okay, I'll just put his I'll use,
Okay.
I'll put him in there.
Okay.
Are we ready to proceed on Mr. Guerra Mendez case?
See,
Mr. Bartolome, are you ready to proceed on Mr. Guerra Mendez case?
yes, Your Honor.
And the interpreter is ready to proceed, is that correct? All right, wonderful. This is cause 642-530, State of Texas versus Juan A. Guerra Mendez. This is a motion to revoke community supervision. Mr. Guerra Mendez, I have a document, 2 documents. I have actually 3 documents for you to identify your signature on. The first one is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. This document is in English. Is this your signature on this document, Mr. Guerra Mendez?
Sí, sí, es mía.
Thank you. And Mr. Bartolome, as attorney for Mr. Guerra Mendez, is this also your signature on this document?
It is, Your Honor.
Thank you. I have 2 more documents, Mr. Guerra Mendez. The first, or they're both entitled Trial Court Certification of Defendant's Right of Appeal. The first copy is in English and the second copy is in Spanish. Are these your 2 signatures, one on each of these documents, sir?
Sí, es correcto. Sí.
Thank you, sir. And Mr. Bartolome, as attorney for Mr. Guerra Mendez, are these your signatures, one on each of these 2 documents?
They are, Your Honor.
Thank you. Once again, for the record, representing the state, Ms. Megan Galloway, representing the Bear County CSCD, Ms. Susan Gross, who our mind is still under oath. Mr. Bartolome, my understanding is this is an uncontested motion to revoke, or rather, hang on, let me get to it. Motion to revoke community supervision. Is that accurate?
That's correct, Your Honor.
Okay.
And
Mr. Guerra Mendez, in clause 642-530 on the motion to revoke community supervision, how do you plead, sir?
verdad. Your Honor,
Yes, sir.
before we get to that point, un momento, por favor, señor. I conferred at the court's direction, Your Honor, with the state yesterday prior to this hearing, at which time it's my understanding that the state was going to recommend that it be withdrawn and modified, Your Honor.
Ms. Galloway, what's going on?
Your Honor, and Mr. Bartholomew, I never said I was withdrawing the
I'm sorry.
MTR. I advised you of my recommendation.
Right.
And I advised you that it is up to Judge Christian to
That
decide
I
what's
realize,
appropriate.
but that's where we're at. So we'd like to know what the state's position. I apologize for the other one. That's my fault. I'm sorry.
Okay, state, are we withdrawing the MTR or are we going forward on it at this time?
We're going forward, Judge. Going
All right.
forward, Your Honor.
Is that correct, Ms. Galloway?
That's correct, Your Honor. We are proceeding
All
with the MTR.
So,
My apologies, Mr.
no problem. Hey, Mr. Guerra Mendez, in clause 642-530 on the motion to revoke community supervision, how do you plead, sir?
True.
Thank you. And Ms. go ahead.
O sea, la pregunta es que si, oye, quiero revocar.
Mr. Guerra, I'm sorry, Mr. Guerra Mendez, Mr. Court accepts a plea of truth with an explanation. Okay, Mr. Bartolome?
Yes, Your Honor.
Fair enough. Ms. Gross, would you please advise the court and the parties of the status of Mr. Guerra Mendez probation, please?
Yes, Your Honor. Mr. Guerra Mendez has been reporting as directed. He's only been on probation since July 15th of this year. He has paid $122 towards his fees. He has a balance of $1,195. He is currently delinquent $150. We have no record of any of his 48 hours community service having been completed. We have no proof of enrollment or completion of DWI education, victim impact panel, or the CATSNP program. He failed to submit to drug testing as ordered on one occasion. He's currently on Smart Start Mobile, testing 4 times per day. He has had 6 skip tests, and as alleged on the motion, he has had 6 high bracs ranging from 0.015, 0.024, and failed to retest to blow those positives to clear. He's also had 0.021, 0.027, 0.022, 0.027, and those 4 have occurred since the MTR was filed. Additionally, he also has tampered with the device. His officer is recommending that his Smart Start Mobile be increased to 6 times per day, that he be placed on weekly drug testing, and that he complete all of his classes within 60 days. This is his first violation report, first motion to revoke, and he has 1 arrest prior to this for criminal trespassing on private property.
Mr. Bartlome, what are you requesting?
Well, first of all, I'd ask that he be continued on probation, Your Honor, and I'd ask that the court consider a monitoring period of 4 times, Your Honor, for a period of time to allow him to come into compliance rather than the 6. And he'd like to address the court, I think, briefly about these tests, Your Honor.
Sure. Mr. Guerra Mendez, would you like to tell us about the problems you're having with blowing in the machine?
Mr. Guerra.
Bueno, sí, o sea, al principio, pues se me pasaron días y sí, yo estuve con el grillete 8 meses, no había tomado nada de alcohol, sí cometí el error pero ya no lo voy a hacer, o sea, ya me quedó claro de que tengo que hacer las cosas como debe ser. Me desesperé, duré 8 meses con el grillete y aparte duré con el grillete y la máquina y sí se me pasaron 2 soplidos, pero la manipulación no ha sido más que, pues que no a la hora de soplar no me pongo nervioso, le soplo fuerte, le soplo despacio, pero así marca, tamper. Pero no, ya no ha pasado eso, ahorita he estado haciendo las pruebas, pero ya no voy a cometer esos errores, quiero ya terminar esto, he estado desesperado y quiero, o sea, hacer todas las cosas bien, eso es lo que quiero hacer.
Ms. Gross, would you please advise the court and the parties of the alleged tampering with the device?
Yes, Your Honor.
Allegation.
Give me just 1 second. I looked at that yesterday and it'll take me a second to find it.
Okay.
On September the 11th at 6:56 p.m. In the photo, it looks like there is a foreign object in the first picture. And then in the second picture, he is blowing into the vise, but he is doing it incorrectly to where he is obstructing the mouthpiece.
Okay, let me back up, and I apologize. I don't see an allegation of tampering with the device as one of the.
That's because it occurred after the MTR was filed.
Right, well, then let's don't consider that. That's for the next one if there is one. So I'm not going to worry about that one. All right, Mr. Bartlome, here's my issue. Is he willing to go on the scram bracelet? It's going to cost him $350 a month. That's the only real tool I have that's going to fix this problem.
No, I understand that, Your Honor. And at this point in time, I think he would consider it. But the question I have is twofold, Judge. Number one, there's other problems in the case besides this one. And that's, I realize alcohol is a major concern. But also, I wanted to address the issue of why he hasn't, or if he's able according to times to get these programs started and done, because you have a short window there of 60 days. And apparently nothing's happened. I'd like him to explain why that happened, Judge.
Just for the record and for your edification, I'm not really excited about the
All
fact that
right,
he has
and we won't address that, Judge. All right. the question-
I'm excited about his drinking. That's what I want to stop. Everything else, we got plenty of time to fix.
Amen, Your Honor. All right, may I speak to Mr. Guerra as we speak? Mr. Guerra, the court's asking you to go to a scram, which is a device that you have to place on your ankle for an additional $325 a month, and it registers any alcohol coming through your system. And that is his alternative. I know, I can see from the SAG, money's an issue. However, that's the court's suggested solution at this time, to continue on probation with conditions. Is that a problem? Señor, is that a problem?
Pues es que he estado batallando para pagar, todavía debo. Tuve un año con el Scrum y la verdad nunca cometí una violación con el Scrum, y tuve la sopladora juntos al mismo tiempo. Dos, así estaba pagando uno y estuve pagando el otro. Y el delito que cometí cuando tuve el Scrum fue que no pagué un día y al otro día lo pagué y lo tuve puesto, pero nunca hubo una violación, solo fue por pago, pero porque he estado batallando para el dinero. Yo no quiero cometer ningún error, ya estoy asustado, no cometí el error, lo reconozco, pero no, ya no vuelve a suceder. Yo creo que me den la oportunidad con los 4 momentos, porque me sale más barato y quiero pagar las horas. Ya no lo pagué porque pues se presentó esto y la verdad quisiera que me dieran la oportunidad, porque estoy pagando las dos, todavía estoy endeudado y tengo que pagar el probation, tengo que pagar, casi he estado pagando más de un año el Scrum, casi un año, perdón, 10 meses estuve, desde hasta julio que tuve la corte, desde noviembre. Y sí he batallado para pagar eso. Quiero
Right.
que me
Go ahead,
ayuden
Judge.
en continuar.
That's all right, Your Honor.
Mr. Bartlome, may I interject for a moment?
You may, Your Honor. I was taking that as a pause.
Here's my 2 options, and I would like you to go back in a breakout room and discuss them with your client if that's possible. Number 1, he can volunteer to do the Scram bracelet, but apparently he's been on it for many months because we had pretrial violations. I have no recollection personally of that, but that's what he's telling us. If that's true, we've got 6 current violations. His options are going to be either A, he volunteers for the Scram bracelet, or B, I got to revoke him. Now, if I have to revoke him, here's the big deal of the day. I see that Mr. Mendez is not a young man just like the judge. But as far as sitting in jail, that doesn't really help anybody, except it will stop him from drinking. If he wants to be revoked, I will revoke him and I will give him a maximum sentence. However, I will give him 30 days to report to the Bexar County Jail. And if he pays the $1,195 he owes the probation department within that 30 days, I will waive his jail sentence. So those are my 2 options.
All right, Judge. Well, I need to go speak with him in Spanish and English, Judge.
That'd be great. Thank you.
We'll be back. In Your Honor, yeah, that's all right. So what? Well, let me
No,
ask this
está bien,
question.
está bien.
Un momento. Your Honor, probation should have a record of whether he's scramming or not.
Oof.
That's what I need to know, because that would have been a condition they would have laid on it.
Well, I
So
think
I don't
probably,
know.
I mean, Mr. Getter Mendez is the one that brought that up. I don't have a finite recollection. I have 1,000 defendants on pretrial and 1,000 defendants on.
No, I understand. No,
So,
I'm asking if probation has a record of that in their file.
I'm looking. No,
Okay.
because that would have been a condition of pretrial, not probation. And he
I
does not have a condition of probation stating that he is supposed to be on a Scram device. The only thing that we show as far as a device that he's ordered to have is a Smart Start mobile.
I understand. All right. We're going to go into the breakout room. Mr. Guerra, we're going to talk in private. All right. What room are you sending this to?
Ok, gracias.
No problema.
Okay, Mr. Martinez, are you ready to,
O si quiere,
Mr.
yo
Portillo.
diría que
No,
pues,
they're gonna put us in a room. They haven't moved
I
us
am,
to a
Judge.
room yet. You have to wait till they
Gracias.
move us to a room. Judge, I apologize. We're still waiting for a room.
no problem.
Morning, Ray.
Morning.
Pat may have stepped away or be on the phone.
Pat, can you hear us? Pat, can you hear us?
¿Cómo?
Tagara, we just hold on. Un momento, por favor.
Gracias.
Well, Ray, the Viking weather's improving, I would think, this morning.
Finally, yes.
Amen.
Hoping to make it out by lunchtime.
There she's back. Pat,
Yes, sir.
can you send Mr. Bartolome and his client to a breakout room, please?
Yes, sir, and I
And the
apologize.
interpreter, and the interpreter. Thank you. All right, we're going.
And does he need the interpreter as well?
Oh, yes.
I thought so.
We need him for all of it. All right. Tell him the number. Well, we're going to just,
4.
okay, number 4.
Yes.
Entrar, dice enviar sesión de grupo pequeño, entrar, ¿verdad? Le pongo.
Sí.
Everybody gone?
Yes, Your Honor.
Okay, Mr.
We're here,
Martinez.
Your Honor.
Mr. Martinez, are you ready to proceed on Mr. Portillo's case?
Yes, Your Honor.
Cause number 639-519, State of Texas versus Juan Portillo. This is a first amended motion to revoke community supervision. And representing Mr. Portillo is Mr. Ray Martinez, representing the state is Ms. Megan Galloway, representing the Bexar County CSCD is Ms. Susan Gross, who I remind is still under oath. Mr. Portillo, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have your signature on it. Is this your signature on this document, sir?
Yes, sir. That is my signature.
Thank you. And Mr. Martinez, as attorney for Mr. Portillo, is this also your signature on this document?
It is, Your Honor.
Thank you. Mr. Portillo, the next document I have for you is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a plea bargain case and the defendant has no, no, that's not the right one. It should be marked as a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions revoking the community supervision, but not the underlying conviction. So Pat, that needs to be fixed administratively. Is this your signature on this document, Mr. Portillo?
That is my signature, sir.
Thank you. And Mr. Martinez, as attorney for Mr. Portillo, is this also your signature on this document?
Yes, Your Honor.
Mr. Martinez, my understanding is this is going to be an uncontested first amended motion to revoke community supervision. Is that correct?
That is correct, Your Honor.
Mr. Portillo, in cause 639-519 on the first amended motion to revoke community supervision, how do you plead, sir?
True.
Thank you. Ms. Gross, would you please advise the court and the parties of the status of Mr. Portillo's probation?
Yes, Your Honor. Mr. Portillo has reported as directed. We last saw him on September 2nd, 2021. He is paid $737 towards his fees and has a balance of $500. He is currently ahead on his payments by $26. He's completed all 36 hours of his community service. He's currently testing on Smart Start 4 times per day and has had no issues, no skips, no bracks. He has completed DWI education, victim impact panel, and the CATSNP program. He has had 9 negative drug tests, and he has had 1 positive drug test for marijuana and 1 diluted drug test. This is his third violation report, 2nd MTR. He has no criminal history, and his officer is recommending that he have his conditions amended, that he go to the CATS IOP program within 10 days, and that he remain on weekly drug testing.
Mr. Martinez, what are you requesting?
Judge, we don't dispute any of that. What we're suggesting to the court is the marijuana was the issue from the beginning. He's slowly weaning himself off of that. He's told me that recently he's been negative on his test. So if in fact that's true, and he's now on a path to staying clean, that the court certainly continue to monitor him with the testing, but I don't think that the treatment program is going to be required if he's in fact staying clean.
Judge, if I may.
Sure.
The defendant has been on probation since February 10th. This marijuana came to light June 29th, so it would not be a residual effect. It would have been a new use issue. However, since that positive drug test, he has had 7 negatives and 1 diluted drug test.
Mr. Martinez, is your client willing to go to the Community Alliance for Traffic Safety Intensive Outpatient Program, or would you rather be revoked and do 90 days in jail?
I'm assuming he'd rather do the program, Judge. I didn't mean to suggest it was residual. What I meant was he was having a hard time getting himself off the marijuana, and he's finally gotten there, I think. But I'm sure he would do the class if that's what the court ordered.
Hey, Mr. Portillo, can you stop hanging out with your buddies smoking the green leafy substance?
Yes, sir. And if I can say something, I wasn't hanging out with anyone who was smoking marijuana. I did buy a bootleg nicotine vape that I think caused the positive THC. And I have quit smoking those nicotine vapes as well.
And what kind of cigarette or something was this you smoked? I'm sorry, I missed that.
It was a disposable nicotine vape that I just bought at a corner store. It should have just been nicotine, but I don't know what's in them, and I quit
All right,
buying them.
let's not do that anymore. Okay, Mr. Portillo, and State, I apologize, State recommendation?
Your Honor, the state agrees with probation's recommendation.
Okay, Mr. Portillo, on clause 639-519, the court accepts your plea of true with an explanation. I deny the state's motion to revoke your probation or to continue on probation with all prior requirements, adding weekly report and UA, or rather be weekly UA, not report.
Judge, he's already on weekly UA,
All right,
so
well,
we'll
then
just be continuing.
We'll continue that. Once you show me 30 days period of time with no diluted tests, no positives for anything colorful, I will put you back on regular monthly UAs. I won't know you've done that. Let your attorney know. He'll let me know, and I'll make the call. CATS, Community Alliance for Traffic Safety Intensive Outpatient Program, and that's really, he's doing everything else, is he not, Pat? Excuse me, Susan?
Yes, Your Honor, he has completed everything else.
All right. We're good, Mr. Portillo. Just hang off the colorful substance stuff and we'll be fine, okay?
Yes, sir.
All right. Anything further, Ray?
No, Your Honor.
Anything further, State?
No, Judge.
All right.
Yes.
Thank you, Mr. Portillo. Thank you, Mr. Martinez. Y'all are dismissed.
Mr. Portillo, you're going to be receiving an email from me later today with your amended conditions. You need to sign them and return them to me, okay? And then you
Yes,
can
ma'am.
get with your officer, and I believe it's Ms. Hernandez, right? You can get with
I
her.
haven't met my new officer yet.
Okay, well, you can call her and then she will get you the information as far as the CATS IOP. But you've already been to CATS, you know where it is. Just tell them that you need the intensive outpatient program and they'll get you set up, okay?
Is that a class I need to take, or what is that exactly?
It's many classes. You're gonna
Okay.
go, I believe, twice a week for 8 weeks, if I remember correctly,
Okay,
okay?
thank you.
All right, if you have any other questions, you can reach out to your officer. She won't be able to see my notes probably until sometime tomorrow because I'm stuck here all day and I don't have time to get it in the computer, but you can call and let her know what happened if you want to, okay?
Do I need to call her? Like I said, I haven't met her yet. I was gonna meet her on my October 7th.
If you're comfortable in going to CATS and getting signed up in the next 10 days by yourself, then
Yeah, I
no.
can go tomorrow. I know where it's at.
Okay, then no, you don't have to touch base with her unless you want to. And then just
Okay.
keep on calling the UA line, okay?
Okay, sounds good.
All right, good luck.
Thank you.
Okay.
We're ready, Your Honor.
Aldis, you ready to
Good
go forward
morning.
on Mr. Collins' case?
We are, Judge. We just wanted to address you briefly. Mr. Collins is there. And
I'm sorry, Mr. Collins, what now? I'm sorry?
well, Judge, he should be there. And this is one you and I spoke about briefly through a message about 3 weeks ago regarding him missing some of the.
Well, let's go on the record and you can explain all that on the record, okay?
Thank you, Judge.
This cause 612208, State of Texas versus Christopher Collins, represented by Mr. Aldis Strouch. This is, let me find it.
Regular.
Got it. A first amended motion to revoke community supervision, representing the state is Mr. Guillermo Flores and Ms. Megan Galloway, representing the Bexar County CSCD is Ms. Susan Gross, who I remind is still under oath. Mr. Collins and Mr. Strouch, the first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. It purports to have your signature on it. In fact, Mr. Collins, is this your signature on this document, sir?
It is, sir.
Thank
Yes.
you. And Mr. Strouch, as attorney for Mr. Collins, is this your signature on this document?
Yes, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal. And if you're not actually talking to me, go ahead and turn your microphone off. We're getting a lot of background noise from somewhere. Thanks. This document is entitled Trial Court Certification of Defendant's Right of Appeal, and it's stated is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. And in fact, Mr. Collins, is your signature on this document also?
It is, sir.
Thank you. And Mr. Strouch, as attorney for Mr. Collins, is this also your signature on this document? Aldis, is this your signature on this document also?
Yes, Your Honor. I'm sorry. I turned off my mic.
Okay, Mr. Strouch, my understanding is this is an uncontested First Amendment motion to revoke community supervision. Is that correct?
It is, Your Honor.
All right, Mr. Collins, in cause 612208 on the First Amendment motion to revoke community supervision, how do you plead, sir? Court accepts the plea of true with an explanation. Ms. Gross, would you please advise the court and the parties of the status of Mr. Collins' probation plea?
Yes, Your Honor. Mr. Collins has been reporting as directed. We last saw him on August 16th of 2021. He has paid $122 towards his fees. He has a balance of $1,190, and he is currently delinquent $396. We have no record of him completing any of his 50 hours of community service, and we have no record of him completing DWI education, victim impact panel, or the CATSNP program. He has had 2 negative drug tests, and he has had 1 positive drug test via urine testing for alcohol. He's currently on the Smart Start mobile device. He has not had any hybrax. He's testing 4 times per day, and he has had 34 skip tests. His criminal history includes arrests for aggravated robbery, fail to stop and give information, theft 100 to 750, possession of a controlled substance, penalty group 1, less than 1 gram, possession of a controlled substance, penalty group 1, less than 1 gram, possession of a controlled substance, penalty group 1, less than 1 gram, fraud, use of a fraudulent.
Judge, some of those, well, many of those were dismissed. I'm surprised she would bring all those up.
Okay, Ms.
Judge
Gross.
just wants to be aware of.
Hang on, everybody stop talking, please. All right, once again, I'm really getting a lot of feedback. So if you're not actually talking straight to me right now, please turn your microphone off. I don't know where it's coming from.
It's
All right.
coming from Mr. Collins because he's outside.
All right, not a problem. Okay. Defense objects to the probation officer bringing up all these arrests because we don't have any confirmation that they're all ended in conviction. Would that be accurate, Mr. Strouch?
Well, we have confirmation that at least 2 of those were dismissed. I'm just surprised. One of them from 2012, and I'll address you when it's our time and tell you what, briefly on those. I'm surprised she would even bring those up.
Well, Mr. Strouch, I sustain your objection, and if you would just give me briefly whatever Mr. Collins has been convicted of, I'm not worried about any other arrests. I agree with you.
Okay, Judge, he did have a possession of controlled substance deferred. That robbery in 12 was dismissed. That felony fraud was dismissed. He's had an assault dismissed. He is on probation for this DWI with you, and we'd like to just, from here forward, we're going to just limit what we want to address the court based on this particular motion.
Okay, that's good to go on that one. Ms. Gross, continue, please.
Okay, and then his officer is recommending that we add a scram device and that he be enrolled in his programs within 10 days.
And is Mr. Collins currently blowing 6 times a day on a Smart Start mobile? Is that correct?
No, he's blowing 4 times a day and has had 34 skips.
I got you. All right, there's the elephant in the room, Mr. Strauss. Why are we skipping all these tests?
Well, thank you, Judge. And I'd like to characterize them as missed as opposed to skips. This gentleman is a hard-working blue-collar worker, Judge, and he works at a company where when he comes home, he's exhausted. And many of these skips, you'll notice, are the evening ones from 10 to midnight. And he has told me he'll come home, take a shower, eat, and get into bed. I think it's noteworthy that he's only had 1 positive UA for alcohol. If all these skips were something sinister and he's trying to sneak in a drink here and there, I think you'd have a lot more positive alcohol. So it's an irresponsible thing on his behalf. One of the company he worked for shut down. He got another job and they started just working him relentlessly hours wise. And some of those quote skipped are really late, if you will, where he didn't make it into the window. Now we agree with the scram device. He wants to, if that's the ankle monitor, we would like to switch to that because he's so busy, but he's somewhat irresponsible regarding remembering, hey, this is very important and I need to do this. I think that the weekly UAs that the probation department, if they're suggesting that, that's a good idea. If there's some thought, well, he might be drinking. The outpatient, we don't have any problem with. Regarding the community service allegation, Judge, and the DWI education, he's only been on this, I think, 3 months. He fully intends to buy out the community service and can do so next week if that's okay with the court with a donation to the food bank. Same with the $396 past due. He can pay that by the end of the next week. His company that he was working for closed down and he had to get into another job and there was a delay with pay of, I think, even a 30-day delay where he didn't have money, but he can pay the $396 next week. He can pay the community service. And I believe he's already registered for the DWI education course. If he hasn't, there's nothing stopping him from doing that. And he certainly wants to comply with that condition. So again, I think these are more missed blows than skipped. And I think if we just acknowledge he's extremely busy, he's somewhat irresponsible, he's fallen asleep on many of those, or he's just been busy at work. And let's just put the device on the ankle to really get a reading if he's trying to get around your conditions. But I don't think he is. And I think he wants to just address you briefly and apologize to the court.
Sure, Mr. Collins, go ahead.
Yes, sir. As he was saying, I do apologize for being irresponsible on a lot of these. As he was saying, I started a new job in this company as a superintendent, and there's been a lot of responsibility put on me at work and a lot of hardworking hours. So, I mean, I did fail on some of these to comply with my windows and just coming home and be responsible. And I do have a 2-year-old son, Christian, and I'm about to have another baby with my wife. I have a lot going on. I've just missed some of these. But I do apologize, sir. If it is something we can possibly do, get the scram device on, I would appreciate that.
Hey, where are you
working? Before.
I'm sorry, go ahead. Sorry. I was going to ask you where you were working currently.
Currently, I'm working for REC Industries. It's a general contractor. So I'm a superintendent for them now. On the sheet metal side, I'm building up a sheet metal industry company. I'm an HVAC.
Gotcha. Aldous, anything further?
Well, Judge, I just think it's significant too. The other thing that the probation officer mentioned, that he's had no high bracts. And so,
Aldous, you
Yes,
don't get a high bracket if you don't blow on the machine.
if you're, well, when he has blown, but I think that if you knew his credibility the way that I do, you would, I believe that he is irresponsible and has fallen asleep on a lot of these. And if you just change it to the scram, you'll be pleased. I don't think it'll serve anything with him going to jail. He supports his wife, his 2-year-old, and this job that he's gotten is finally really paying him a fair wage. And he's moving in the right direction, Judge. So we ask that you deny the state's motion and continue him with, the outpatient he signed up to do anyway, and the weekly UAs. And I think you'll be pleased with the results.
Ms. Gross, anything further?
No, Your Honor.
State recommendation?
Judge, the state recommends that the defendant be continued on probation. And also, we agree with the scram device. We also request that you tell the defendant to CAT SNP program within 10 days. And Judge, we also recommend weekly UAs for at least 4 weeks.
We don't object to any of that, Judge.
Has Mr. Collins started the CAT-SNP program? Does anybody know?
We have no record of that, Your Honor.
Have you started the CAT-SNP program yet, Mr. Collins? Have you gone to any classes?
Sir, I haven't done the classes. I've only registered for the impact.
I got you. Okay, I got it. Hey, Mr. Collins, it costs 612208. Court accepts your plea of true with an explanation. On the first amended motion to revoke community supervision, I deny the state's motion to revoke your probation or to continue on probation with all prior requirements, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary?
No, sir, it won't be.
Good answer, sir. Altering amending conditions, adding the scram cam ankle bracelet within 5 days. And there may be a scheduling issue. If that, get with Mr. Crouch or get with me, and we'll give you more than 5 days, whatever it takes.
Thank you, sir.
Adding weekly UAs. Once he shows me 4 clean weekly UAs, Aldous, in a row, I'll put him back on monthly UAs.
Thank you.
I won't know he's done that. He's got to tell you. You got to tell me. I'll confirm it. Susan, let's switch him to Community Alliance for Traffic Safety Intensive Outpatient. He's got a historical record of some sort of drug use. We'll just put a little bit more punch in that course.
Okay, and you're gonna waive CAT SNP
And
then?
waive the regular CATS program and put him on substantial compliance within 10 days. Ms. Collins, what that means is any programs that you haven't registered for yet, you got to be registered for within 10 days. You may not start, but you got to be registered so you know what's coming. Fair enough?
I understand, yes, sir.
Aldous, anything else? Will that work for you?
No, Your Honor, that works. Thank you very much.
All right, state anything further?
No, Judge.
All right, good luck, Mr. Collins. Thank you, Mr.
No,
Collins.
no, don't go anywhere. You always forget me, Judge. Mr. Collins, later today, you're gonna be receiving amended conditions from me, okay? You need to sign those and send those back. They're gonna come via Adobe Sign, okay? You can touch base with your officer, Ms. Wilcox, and let her know what happened today. And then we'll get you a referral slip for the scram device.
Yes, ma'am.
Okay, do you have any questions?
I don't.
All right, good luck to you, sir.
Thank you, Judge.
Thank you, ma'am.
All right, you bet. Y'all take care. Okay, back on the record on cause 642-530, State of Texas versus Juan A. Guerra Mendez. Mr. Bartolome and Mr. Guerra Mendez and the interpreter have been in a breakout room discussing their options. What do y'all want to do, Mr. Bartolome?
All right, Your Honor, we've discussed the options. Obviously, my client is interested in continuing on scram. I have one question.
Sure.
The question for him is he spent a year on scram, Your Honor, with the bond, and he makes about $600 a month. So it's created a extreme financial hardship. Secondly, and more importantly, he still owes scram $500 from the transition in the last situation from the scram to the portable device. And at the time he went, he had to go to Belverde to get one on because they didn't have one in Bexar County. My question would be, would the court pay for the scram, Judge?
I'm sorry, will the court do what with the scram?
Pay for the scram, Judge.
I don't think I have the authority to pay for the scram.
Well, then
Susan, do I have the authority to pay for a scram bracelet?
No, and also, Judge, they will not put a scram device on him until he clears up any past bills and then pays a new deposit and 1 month's services.
So I mean, he's in the hole already, Your Honor, 500, and he's going to be up about 700 more by the time we get this thing laid out. So my question would be the following: that creates an economic conundrum Now, my original suggestion was, and this is up to him, not to us, is whether or not, Your Honor, we continuing on monitoring on the program that he's on now and see where we are with alcohol if he gets the message.
After
Or
6 positives for alcohol, I think I know where we are in alcohol. That's our
Well,
big issue.
I understand that, Judge. The question is, but then there's an interim period, Your Honor, to round up the funds to pay off 500 and come up with the new deposit in the down. So then my question would be, we're still in a monitoring program if we continue him on that, Judge, and let him get back to scram if he has to.
All right, here's my concern, and I'm guessing it's the state's concern also. Apparently, Mr. Garamendez had a colorful history on pretrial to the point where apparently he was still drinking, and I put him on a scram bracelet back then, and he had to incur the expense for however many months under that deal. But apparently that worked because, you know, here we are today, and he's actually on probation. He's got 6 positives for alcohol on the Smart Start mobile device, which means he is still blowing in the machine. Mostly, he only had 6 skips that I see. But I don't see a warm fuzzy future for Mr. Garamendez stopping drinking. So I mean, I think we're setting him up for failure if we continue doing this. What do you think?
Well, here's what I don't disagree, Your Honor, except for this point. If you're already
¿Me escucha? Ahí.
Un momento. The question is, can he pay the back money and come up with the down payments? And that's the issue. That is the issue. That's a question you have to ask him, Judge, because I don't have all of his finances under control. Mr. Guerra, go ahead.
Ok, no, bueno, pues yo continúo, no hay problema. Yo continúo, yo me las arreglo.
Go ahead. Okay. All right. Let me say this so he can hear it again. I apologize to the court and to Mr. Guerra. Mr. Guerra, probation has informed us that if you put the scram back on, you will have to pay the back payment, the new cost, and a down payment to install it, which means you have to pay the old bill plus the new monies to put on the scram. Do you have those monies available? That's what I was talking to the judge about, because it's the 500 you owe plus the deposit for 1 month and the deposit plus 1 month's payment. Do you have that kind of money available? That's the pregunta.
No, pues,
Pardon?
It would be probably close to $1,000.
no, yo lo consigo, no se preocupe. No, pues los voy a conseguir para continuar en libertad.
All right. With that said, then, Your Honor, if he has to get that money and he can do it, then obviously, Your Honor, we want to continue on probation with scram as a condition.
If you do the math and you take the $500 back money he owes to scram people and the $300 plus or minus dollars a month is going to cost to keep scram active, it won't take long before you burn up the $1,195 he ultimately is going to owe the probation department. And then he doesn't have to deal with us anymore. So I don't see a real benefit to keep him on probation and set him up for failing again. He's already failed over and over. Ed, I will follow your guide. If you want him to do all this stuff and he's willing to pay the money and he can get on a scram bracelet within 10 days, I'll continue him. And I'm telling you right now, he's not going to make probation at the rate we're going. I think it'd be far better beneficially to him monetarily to go ahead and be revoked and have 30 days to report to jail and pay the $11.95 and be off probation. But that's between you and your client. I'll give him a shot. But I'm telling you right now, from what I see historical trend wise and currently, he's not going to make it. And we're just going to be back here again. But I'll give you,
Your Honor, at this point in time, I believe it's my client's desire to continue to demonstrate to the court that he can make probation and that is the plan. Now, if he tells you he wants to go to jail and clean this up, you can ask him right now, because he's expressed to me continually the desire to continue on probation because of the problems that he's had in the interim. And he understands.
And let me try to make clear, because maybe I wasn't clear before. If he is interested in being revoked, I'm going to give him a maximum sentence of 6 months in jail, but I'm going to give him a 30-day delay before he has to report to jail. And if he pays the $1,195 to the probation department within that 30 days, I'm going to waive his jail sentence so he doesn't have to go to jail. Does he understand that clearly?
Now that, okay, ask him if he understood.
Sí, o sea, voy a,
So what he's saying, Mr. Guerra, is
que pague lo-
no, if you pay the $1,095 fine, he'll waive, you won't have to go to jail and it'll be all over, right, Judge?
That's correct.
Within 30 days.
He's already found guilty of DWI.
Sí, ok, los pago.
All
Sí,
right.
sí,
All right, Ed, do me a favor. Please go into a breakout room one more time. I want to make sure it's crystal clear in Mr. Guerra's mind exactly what we're dealing with. Let me restate it for you. We do this quite often with folks that are in Mr. Guerra Mendez circumstance, but he's already pled true. I'm going to accept his plea of true. I'm going to grant the state's motion to revoke his probation.
Right.
I'm going to sentence him to whatever his original fine amount was. Susan will look up for me, and 6 months in the Bexar County Jail. But I'm going to give him 30 days from today to report. And if he pays this $1,195, which is the total amount of money he would owe the probation department if he stayed on probation, within that 30 days, I will waive his jail sentence, so he will never have to go to jail. He's already got a conviction for DWI, so I just think that's probably the point of least resistance. But I want you to make sure you chat with him and make sure that's clear in his mind. That's what he's willing to do.
All right. All right, Mr. Guerra, do you understand?
ok, entonces me voy otra vez a entrar en grupo pequeño.
Yes. Y'all go back into 3.
All right. Do
Yes,
that.
and I've already, all they have to do is go back into 3. You all.
Ed, let me restate, because I apologize. Perhaps I haven't been crystal clear. I will keep him on probation if that's what you and he want him to do, but he needs to get on a scram bracelet within 10 days. And he's going to have to pay that back $500 plus the $300 or whatever dollars, and plus the reinstatement fee, if I were guessing, and then another $300 something a month until his probation is over, or he stops drinking, whichever comes first, and he stays on probation. Or I will grant the state's motion to revoke him, give him a sentence of 6 months in jail and whatever his original fine amount was, and credit for time served, et cetera, et cetera. But give him a 30-day delay before he has to report to the jail and serve his jail sentence. And if he pays the $1,195 he owes the probation department, or ultimately will owe them, during that time frame, I will waive his jail sentence. You will never, ever have to go to jail. Is that clear?
That's correct, Your Honor. So he has 30 days before he'd have to go to jail if he chooses.
That's correct.
I got it. If you revoke him, I got it, Judge. All right.
So watch him go back and make sure it's crystal clear in his mind, because I don't want him to be confused. I want him to make a valid election on what he wants to do.
As we all do. Thank you, Your Honor, for your.
All right.
Sí.
Break on that one. Okay, Ms. Corley, you ready to proceed on Ms. Yezel Guerrero?
Your Honor, they have not
Judge-
done the paperwork.
Okay.
Yeah,
Okay.
we need to do the paperwork and I need to go into a breakout room with my client again.
And I've
Me
already
dice,
put y'all in 6. Both of you can go.
aquí nomás me dice entrar a la sesión de grupo pequeño. Le pongo entrar.
8 o'clock this morning.
Okay.
8:40 something this morning.
I'm so sorry. I could not understand what you're saying because of Mr. Guerra.
So you can send Linda and her client back to
I've
break.
already, Judge, I have already put you all in. You can go into breakout room 6, both you and your client. And I have checked and I sent you, Miss Corley, the paperwork this morning at 8.
Oh, I do see it now. I'm sorry. I missed it. I had to, when I found the time, I could have narrowed down where to look. I apologize. Yes, ma'am. We will go do that. Will she have the ability to share screen so I can look at the paperwork with her?
I don't know whether y'all do or not. I can put it on there. You can try, but.
Okay.
All right.
I'm gonna go get somebody really quick to help me.
You're in the breakout room.
Sorry for the commotion, everybody.
That's okay.
Can you call him?
let me see if I can move y'all into another one or see, because y'all are you're prepared to go into 6. All you need to do is hit your buttons.
Linda, your microphone is turned off. We can't hear you.
She should be able to go into room 6.
I think she got it. Okay, Mr. Farmer, you ready to proceed on Mr. Sanchez?
Yes, Your Honor.
Give me about 2-minute break to get some more water. I'll be right back.
Okay.
Ms. Guerrero, you should be able to go into breakout room 6. Mr. Guerra. Looks like let me see what happened. Let me see if there's a reason. He's in 3. Let me put him in 4 right now. Okay.
Yeah, I'm
Let's
on
see if
my
that
way.
worked.
I'm on my way. Thank you.
Go into 4. I sent him in 4. He was in 3. I don't know. You all were in 3 before, so it might be that. Okay. Interesting.
Pat,
Yes.
it's easier for us to go to 3 than him to go to 4, apparently.
Okay, let me see what I can do. He's out of the room completely.
Well, is he in 4 now?
No, he's out. Totally out.
Yeah. Well, maybe he's going to pay the $1,095. I don't know. Ay.
Okay, Judge, Mr. Getup, for some reason, it got out. He's completely out. But Mr. Farmer and his client is here. And as soon as he gets back in, I can put the interpreter and Mr. Bartholomew back.
Okay, Ed, do you have a cell number on?
Oh, yeah, we do. We're going to call him right now, Judge.
Okay.
Thank you.
I'll figure that out. All right.
I guess maybe he already made up his mind that he was going to pay. I don't know.
Understand. Y'all figure it out.
Hey, and Ed, also on top of that $1,195, I believe it was, there's a $2 payment fee. Just so you know.
Mr. Bartolome, a really nice lawyer would just lend his client that money and get it resolved immediately.
Right?
Okay, we ready to proceed on Mr. Sanchez's case? Mr. Farmer?
Oh, yes, Your Honor.
It's cause number 657492, State of Texas versus Cedric Sanchez, represented by Mr. Sean Farmer. This is a motion to enter adjudication of guilt and revoke community supervision. Mr. Sanchez and Mr. Farmer, the first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both your signatures on it. In fact, Mr. Sanchez, is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Farmer, as attorney for Mr. Sanchez, is this your signature on this document?
Yes, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Is this your signature on this document also, Mr. Sanchez?
Yes, sir.
And Mr. Farmer, as attorney for Mr. Sanchez, is this also your signature on this document?
Oh, yes, Your Honor.
Representing the state, Mr. Guillermo Flores and Ms. Megan Galloway. Representing the Bexar County CSCD is Ms. Susan Gross. I remind is still under oath. Mr. Farmer, my understanding is this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, Your Honor. My client, I guess, admits to violation of condition 2. However, he does dispute violation of condition 15 and 16, which have been satisfied.
Understand. What we normally do is let them plead true with an explanation or not true with an explanation and explain it. If he's willing to go to me, obviously, as the trier of fact with regard to making a determination. If he wants a really contested knockdown drag out, we'll get his probation officer online and go from there, but that's up to you guys.
Your Honor, he true to the allegation. Sorry.
All right, fair enough. Let's see, Mr. Sanchez, in cause 657-492 on the motion to enter adjudication of guilt and revoke community supervision. How do you plead, sir? Mr. Sanchez, can you hear me?
No, sir, I did not hear you.
Let me back up. In cause 657-492 on the motion to enter adjudication of guilt and revoke community supervision. How do you plead, sir?
Guilty?
Well, for purposes of an MTR, we either plead that the allegations are true or that they are not true. Would that be accurate, Mr. Farmer?
Oh, true.
Yes, sir.
Okay, so court's going to accept the plea of true with an explanation. Would that be okay, Mr. Farmer?
Yes, Your Honor.
All right. Ms. Gross, would you please advise the court and the parties of the status of Mr. Sanchez's probation, please?
Yes, Your Honor. Mr. Sanchez has been reporting as directed. We last saw him on August 6th of 2021. He has paid $90 towards his fees. He has a balance of $737 and he is currently delinquent $90. We have no proof of completion of any of his 36 hours of community service. He has completed the drug offender education program. He was ordered to take a firearms safety class, and he provided a certificate of completion for hunting responsibility. I'm not sure if that would qualify or meet the court's expectations. He has had one positive drug test for marijuana and one diluted drug test. His criminal history includes arrest for assault, bodily injury, married, evading arrest and detention, and a possession of marijuana 0 to 2 ounces. His officer is recommending that he be placed on weekly drug testing and that he enroll, and that he enroll in his classes, but he has since completed all of those.
Okay, so he's done the DOEP and he's done the gun class, correct?
Yes, Your Honor.
Yes.
And are there any other classes that he was initially assigned?
He only otherwise had community service judge, and we don't show any of those hours being completed, but he did complete the other court required classes.
Okay, Mr. Farmer, what's your request, sir?
Sorry, Your Honor. Let me see. Sorry, I was going down. As far as his completing the courses, he has completed the courses. He did test positive for marijuana. He did inform his probation test positive and stated that following like a period of a month, he should be clean. Let me see. And right now we are in agreement with the state's recommendation to have him do weekly UAs. And as the previous attorney also mentioned, we do object to the mention of the previous criminal history because those cases were dismissed. And I do not know why we would want to modify his conditions of release at this time. He was placed on, I guess, a GPS monitor and he's on house arrest and he needs to work. He currently does have a job and he is supporting infant and 2 toddlers, and it's creating a financial hardship for him. So at this time, we would like to continue him on probation and modify his conditions of release to have the alcohol or the bracelet removed.
Hey, Mr. Sanchez, where are you currently working, sir?
I'm a manager at Crab Kings. It's a food truck.
Gotcha. State recommendation, please.
Judge, since the defendant completed the courses, as previously stated, the state recommends a modification of the conditions of probation, weekly UAs for at least 30 days.
Susan, what was the original fine on this case, if you know?
Yes, Your Honor, the original fine was $200.
And 36 hours community service, is that correct?
Yes, sir.
Mr. Sanchez, in clause 657492, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of unlawfully carrying a handgun. I sentence you to 1 year in the Bexar County Jail, probated for 1 year. Assess a $200 fine plus court costs. 36 hours community service, Community Alliance for Traffic Safety New Intervention Program. Weekly UAs, show me 4 clean weekly UAs, no dilutes, no positives for anything colorful. And I'll crank him back down to monthly UAs. I won't know if he's done that. So if you do that, sir, you need to tell Mr. Farmer, he'll tell me and I'll confirm you've done that and I'll make the call. Substantial compliance in all these areas, any programs you're not registered for already, which I'm sure is catnip at least, you need to be registered within 10 days. You may or may not start classes within that. We're going to waive all prior bond conditions like GPS and all those other things. Susan, what did I miss? I'm not going to do the order the gun class. He's already done that.
Did you order substantial compliance? I think you started to, but you didn't finish.
Substantial compliance in 10 days, meaning he just needs to be registered for any programs he hasn't formerly done at this time.
So he gets credit for all prior monies and classes.
Correct. Credit for all prior money and classes. He went on probation on July 2021. So he's only been on probation for a couple of months. All right, that's what I got. Anything further from the state of the defense on Mr. Sanchez?
So, Your Honor, what was the other class that he needs to register
Well,
for?
the outpatient drug courses, Community Alliance for Traffic Safety New Intervention Program. We already sent Mr. Sanchez to the DOEP program, and that obviously didn't work, but we came up with a positive for marijuana. So we need to go the next step up on outpatient drug course.
Okay. And then as far as the community service, how long does he have to complete that, or is it till the term?
Till the end of probation, you know, but he,
Okay.
he needs to be on his radar. He can donate $10 an hour for the 36 hours to a court charity, which are primarily Special Operations Wounded Warrior Organization or Family Violence Prevention Organization. Or
His
he
officer can give him that list.
yeah, or he can just find something he wants to do community service wise and do that. But we've got till the end of probation for all that. That's not a life and death has to be done today deal.
Great. Thank you, Your Honor.
All right. Anything further from the state of the defense on Mr. Sanchez?
No, Your Honor.
Susan, do you need to
Okay.
chat with Mr. Sanchez briefly before we cut him loose?
Yes, Mr. Sanchez and Mr. Farmer, Pat will be sending you new documents. It will be an application for probation and a data sheet, because Mr. Sanchez, you're gonna have to go back through orientation all over again, okay? So watch your email. They'll be in touch with you for you to come in and go through orientation and sign new conditions, and then they'll give you all your new referrals. Your question?
When will the monitor be taken off?
The judge is going to put the paperwork in today, so you'll probably be able to go in and get your ankle bracelet off sometime tomorrow.
Okay.
Any questions, Mr. Farmer?
No, thank you.
Okay, so Mr. Farmer, I'll send it to you first to fill out the initial part of the application, and then it will go to Mr. Sanchez, and I'll send it in just a few minutes. Judge, you need to sign Ms. Guerrero's and Mr. Moya's paperwork.
Okay, let's take a quick break and get that done. Let's see, we've got, we have Mr. Bartolome back yet?
No, they're still in there.
I got you.
Thank you, Pat. And may I be excused, Your Honor?
Yes.
Okay.
Pat,
Excuse me.
may
Yes.
may I be excused?
Yes, you can go.
Okay. Okay, thank you. Sorry.
All right. Just watch out for that paperwork.
Okay, Linda, can you hear me?
Yes, I can, Judge.
All right. Are you ready to proceed on Ms. Guerrero's case?
Yes.
Okay, this is cause 654435. Data Texas versus Ashley Yezel Guerrero. This is a motion to revoke community supervision. Ms. Guerrero and Ms. Corley, the first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have each of your signatures on it. In fact, Ms. Guerrero, is this your signature on this document, ma'am?
Yes, Your Honor.
Thank you. And Ms. Corley, as attorney for Ms. Guerrero, is this also your signature on this document?
Yes, it is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction, unquote. Is this your signature on this document, Ms. Guerrero?
Yes, Your Honor.
And Ms. Corley, as attorney for Ms. Guerrero, is this also your signature on this document?
Yes, it is, Your Honor.
This is a motion to revoke community supervision. My understanding is that it is uncontested. Is that accurate, Ms. Corley?
Judge, we can plead true to everything except number 13. She was not driving. She was getting out of a car as a passenger.
Okay, why don't you just plead true to everything except 13 and not true to that if she wasn't driving? Is that fair?
That's fair.
Okay. Representing the state, Mr. Guillermo Flores, and Ms. Megan Galloway. Representing the Bear County CSCD is Ms. Susan Gross, who I remind is still under oath. Ms. Guerrero in cause 654435 on the motion to revoke community supervision. How do you plead, ma'am?
True.
And Judge, we're pleading true to everything except condition number 13 of driving a vehicle. And Ashley, you're pleading not true to that.
Fair enough.
Yeah, it's not true. Sorry.
And Ms. Gross, would you please advise the court and the parties of the status of Ms. Guerrero's probation, please?
Your Honor, Ms. Guerrero has been reporting as directed. We last saw her on August 2nd, 2021. She's paid $114 towards her fees. She has a balance of $990, and she is currently delinquent $219. We have no record of any of her 24 hours of community service having been completed. And we have no record of completion of DWI education, victim impact panel, or the CAT-SNP program. She does also have a condition of probation that she is not to operate a motor vehicle without a valid Texas driver's license. She is currently on Smart Start Mobile testing 4 times per day. She's had 13 skips, and she has been in lockout since August 16th of 2021. She has no high bracs. This is her first violation report, first motion to revoke. She has 1 prior arrest for possession of marijuana, and our officer is recommending that she increase her Smart Start to 6 times per day.
Ms. Corley, what are your requests?
Your Honor, I'd like to bring the court's attention that she has missed some tests. Apparently those were a result of a few of those. She overslept the alarm. Judge, the other ones, she works in a secure area dealing with financial documents, and her supervisor would not allow her to bring in the mobile device. I believe that has been resolved now that the supervisor understands that she ended up in jail because she missed those blows. She's going to allow her to bring that device into work now. In addition, Judge, she has completed the victim impact course, and she did turn that certificate in, I believe, sometime in September. So it was after this was filed. She knows she has the other classes. She just started on probation in June, Your Honor. So she understands that she needs to get all of these classes successfully completed, and she was working towards that, Judge. So I understand they're asking to increase her blows to 6 times a day. We would request if you would allow her to stay at 4 times a day and perhaps amend those times for the blow, so she makes sure she doesn't miss those. I have talked with her, and she understands how important that is. She got locked out of the device because, and she had explained this to her probation officer, apparently her husband got COVID. He was isolated. She had all the symptoms for COVID, although she didn't go to the doctor. They isolated themselves, so she was short on money and was not able to pay the device. Her circumstances have changed since then, Judge. She has received apparently a check from the IRS. And so I'd like to present if she could probably pay all of her remaining fees that she's owed if the judge, if you wanted to revoke her. But she does need to get out to do that with her card. I've talked with her husband, but I haven't been able to get through to him this morning. So if that's an option, if we could get a PR bond and let her, so she could go pay those and then have another hearing and she would have those paid for the revocation.
I assume she wants to stay on probation, though, realistically. Is that not true?
Well, she wants to get out of jail, Judge. That's for certain. But if you did give her a PR bond to allow her a bond out, she could pay those in full and then have her probation revoked, and she would have everything paid.
Ms. Gross, I'm looking at my notes. How many skipped tests do we have? 13?
Judge, we have 13, and then she went into lockout on August the 16th of 2021. And it looks like she got the machine going again on September the 4th. So she was out of service for about 2.5 weeks. And since she reactivated the device on the 4th, she has missed a total of, hang on here, $13 tests, but I believe 8 of those occurred since she's been in jail.
And Judge, she did have about 331 tests that were clean. And also they did a UA on her on August the 2nd, and that was clean.
Okay, state recommendation, please.
Judge, the state recommends 6 times or modify the Smart Start mobile device from 4 to 6 times per day. And if that doesn't work, we also recommend the Scram device.
Okay, Ms. Guerrero, on cause 6544435, the court accepts your plea of true to all allegations on the motion to revoke probation except number 14 and not true to that one with an explanation. I deny the state's motion to revoke your probation, or you continued on probation with all prior requirements with no sanction at this time. Altering many conditions, modifying your Smart Start mobile from 4 blows a day to 6 blows a day within 24 hours of right now. If you show me a 30-day period of time starting right now without missing any blows at 6 blows a day and no hybrax for alcohol, I'll crank you back down to 4 blows a day. I won't know you've done that. You got to let your lawyer know. She'll let me know. I'll confirm it with probation and I'll send it in. So that takes care of that.
And Judge,
Yeah.
It was actually not 14 that we pled true to, not true to. It was 13 that we pled not true.
Oh, I'm sorry. Let me go back and clarify that. Yeah, apologize. Not true to 13, true with an explanation to 14, correct?
Yes, Judge.
I got you. And even though you weren't driving a vehicle without a valid Texas driver's license before, let's make sure it doesn't happen in the future either. So that takes care of that one. Substantial compliance within 10 days, meaning any program she's not currently registered for. I want her registered for within 10 days. She may not start going to classes and doing things, but at least she'll know what's coming. And Susan, what else do we need to do?
Judge, I believe that covers it.
You got to blow on the machine. If you don't blow on the machine, then we're back to scram or jail. And I think you've already experienced jail, and that's not any fun. So
Yes.
Yeah, she's been there about a week, Judge.
well, then I don't think we'll have any more problems. Do you?
Absolutely
No.
not, Judge.
Do you have anything further to say, Ms. Square? Or are you good?
No, I would just like to thank you.
All right.
That's it.
I'm gonna send in the order today. You probably won't get out of jail till late tonight or tomorrow. That's the way the jail works. I'm sorry it's that way, but it's that way. Then you're just back on probation and start knocking this stuff out. And when people say, "Hey, Ashley, let's go drinking," you say no, and then they'll take care of that. Okay.
Right. Thank you.
All right. Ms. Corley, anything further?
Nothing further, Your Honor.
All right. Good luck, Ms. Guerrero. Susan, go ahead.
Ms. Guerrero, you will probably, by the time you get out, you will have an email from your officer with your amended conditions of probation. You need to sign those via Adobe Sign and send those back. And then as soon as you get out, probably tomorrow, will be the first chance. Call Miss Hernandez and she will give you your new testing times, okay?
Okay, thank you so much.
All right, good luck to you.
All right.
Ashley, do you have her contact information, your officer?
No, not with me, not available.
Can that be emailed to her, Susan?
I can give it to you right now. Her
Okay.
officer's telephone number
Mhm.
is 210. Come on, there we go. 335-7334.
334, and I'm sorry, what was that officer's name?
Crystal Hernandez.
Hernandez. Thank you.
Mhm.
I'll send that to you, Ashley,
Okay,
and if you have any
thank
questions
you.
about it, just call our office when you get out, okay?
Okay, thank you, thank you, thank you, everybody.
Thank you.
All
Thank
right.
you.
Good luck, guys.
Thank you,
Thanks.
Judge. May I be
You bet.
excused?
You bet.
Thank
Thank
you.
you.
Okay, we don't have back Mr. Bartolome and Mr.
No.
Garamondez. Anybody know what the status of those folks are?
No, Your Honor, do you want me to go in and check?
No. They'll
Okay,
put them
go
check.
ahead.
Okay, we've got Mr. Moya and cause 660-412, and we've got some sort of secret meeting that we're supposed to have between the state and the defense and the court. Is that correct?
Well, there was something he wanted me to relay to the court, but he didn't want to do it in front of everybody else, Your Honor.
Are you ready to proceed now? Is that what we're doing? We don't have anybody else here except the entire world who wants to watch on Zoom on YouTube.
Well,
I mean,
do you want to go in the breakout room? We can do that. I need to know.
I mean, nobody's in the room now. I'm perfectly okay with it being handled
Okay,
right
you
now.
need to understand you're on YouTube.
We're live on YouTube.
Okay, then maybe we should do
Yeah.
the. I'm sorry. Yeah, maybe we should do the breakout room if that's
So
possible.
it
sir.
would be Judge, you and the attorney?
All right, let me back up. We're not going to do the procedure, any of this stuff in the breakout room. What are we talking about something that's confidential in the breakout room?
Yes.
Judge, there's sensitive information that needs to be.
All right, well, hang on. We've got Mr. Bartlemy back. Let's find out what's going on with
I
him.
need to talk to the court. I need to look at the file now in this case because there's a question, Judge.
What's the question?
Here's the question. My client's understanding is that he had a criminal trespass and a DWI, and that the court apparently they took into consideration the trespass when he entered the plea to the DWI, and that there was, then there were conditions, and I need to see if that's what the judgments say because he said he did them both at the same time.
All right, so your understanding is there was a criminal trespass that was TIC'd on the plea on the DWI. Is that your understanding?
Right. That's right.
I believe so.
Been dismissed. And see that
Let's
the
see if
question
Susan
is,
can figure it out.
he's got a
I'm looking it up
$10,000.
right now.
Hold it, Judge. He's got a $10,000 bond posted with immigration. He's been waiting for a hearing for 3 years. So, it's kind of important to him where the record sits for purposes of every year the hearing gets postponed, but he's posted a bond and he has a lawyer. But he told me that both of these cases came up at the same time, trespass and a DWI, and that I believe the trespass was taken into consideration at the time.
I believe so.
Hang on 1 second. I'm looking it up.
For conferma.
Yes, it was TIC'd and it shows dismissed convicted other.
Right, which means he can't get it off his record. Okay, I got it.
Well, he can't get the DWI off his record. The other one, except as an arrest, is on his record, but it's not a conviction.
That's true, Judge, but you can't. But for purposes of immigration, you never know what they want to do with it. That's all.
I hear you.
You know what I'm saying? All right, I was correct. We're going to take the 1197, Judge. So that's the plan.
Okay, is Mr. Garamondez back on Zoom with us yet?
No, Your Honor, but I can get him back in.
Let's get him back so that we can go on the record and clear this up.
And we'll let him know that court was taken into consideration and dismissed.
Okay, we can do that.
That too. And
Okay, I've shot them back in. They should be coming in. They should be. That doesn't mean.
Yeah, that's true.
Again, let me.
Susan, what was the original fine amount on Mr. Garamondez's case, please?
It was $500, Your Honor.
Thank you.
Let me go in and get them out. Because there he goes.
And Susan, do you have the criminal trespass cause number that was TIC'd on the original plea on the DWI?
Of course.
And it
You
would.
ready?
Yeah.
589710.
They're in, Your Honor.
Thank you. And was this a criminal trespass in a private place or what was it? Do we know?
Criminal trespass, private property.
Yeah. Who was his lawyer on that case?
Joanne de Hoyos.
Who?
Joanne de Hoyos.
Well, he was in good hands with Allstate. No problem.
All right, back on the record on cause 642-530. State of Texas versus Juan A. Guerra Mendez. Mr. Guerra Mendez and Mr. Bartolome having had an opportunity to confer with the interpreter present in a breakout room. They are now back. And Mr. Bartolome, what would Mr. Guerra Mendez like to do with regard to the termination of his case?
Your Honor, he would like to pay the $1,197.05. I believe that's the number within 30 days, Your Honor.
Pat, what is 30 days from 23 September?
October 23rd, but that's a Saturday.
What's the following Monday?
October 25th.
Will that work, Ed?
That's fine, Judge.
Yes, ma'am.
It'll be paid before then, I think, but the 25th is the absolute date, correct? El último día. All right. We're ready if the court is, Judge.
Okay.
Do we have the interpreter?
¿Sí me oye?
Yes.
Okay, do we have our
Yes.
interpreter on? All right.
Yes.
All right, let me go to interpretation. All right. Mr. Guerra,
Hey,
in answer to your initial question, we reviewed the court's file and the judge will tell you what the disposition was with regard to the criminal trespass and your DWI. Your Honor, if you would address Mr. Guerra, please.
Okay, have we got our interpretation working now, Norma?
No.
No. He needs to go to his cell phone and hit the 3 dots.
All right. Mr. Guerra,
Pat, can you tell him in Spanish?
No, not as well as she can, but
Yeah, but she can't, he can't hear her.
but he can, I believe he can hear her. Señor Guerra,
sí,
necesitas ver los 3 puntos. Y otra vez,
on su teléfono.
en su televisión para que puedas verificar del el interpretation.
ok,
Otra vez, necesitas, por favor.
sí.
Ok.
Espérame.
And,
Ay. Interpretación de idiomas.
sí,
Español.
en
Ok.
español, sí.
Gracias, es que se sale y entra.
Finish.
Discúlpame. Ya. Sí, es que no le puse.
Okay. Now, Judge.
Sorry.
Okay, back on the record on cause 642-530, State of Texas versus Juan A. Guerra Mendez. Mr. Guerra Mendez, we went back and checked the record back from your original plea on the DWI case, which was cause number 642-530, which was entered on or about July 15th, 2021. And at the time you went on probation for the DWI that we're here on today, you had another case on criminal trespass on private property, cause number 589710. And that was taken into consideration on the plea on the DWI. So that was ultimately dismissed. Is Mr. Bartolome, is that your understanding of what happened?
That's his recollection, Your Honor, and that's what I was asking the court to clarify.
Right. So that case is no longer valid
And it was
anywhere.
not a conviction, it was dismissed.
Correct.
Thank
So on this case, which is cause 6425, go ahead, sir.
You have a question, Antonio? Tenemos una pregunta de el juez.
No, entonces, o sea, va a ser como dijo el abogado, que pague el total, el doble A y el traspaso se limpia. ¿Es correcto?
Your Honor?
Yes, that's correct.
That's correct.
Ok. Ok, no, ok, tenía confusión, sorry. Ok, entonces.
No problem. If you have any other questions on this or anything else, Mr. Guerra Mendez, now's the time to ask us. We'll be happy to answer your question. Let me tell you what my understanding of what we're going to do on this case is at this time. In the current case, the DWI case, called 642-530, on the motion to revoke community supervision, my understanding is that I'm going to accept your plea of true. I'm going to grant the state's motion to revoke your probation. I'm going to sentence you to 6 months in the Bexar County Jail, assess a $500 fine plus court costs, credit for time served, time and money to run concurrent. I'm going to order you to report to the Bexar County Jail at 9:00 a.m. on Monday, October 26, 2021, which is a little over 30 days from now. Between now and then, if you pay the Bexar County Adult Probation Department $1,195, and I think there's also a $2 fee for processing. At that time, I will waive your jail sentence, so you will not have to go to jail. You've already got a conviction for DWI, so there's no other real adverse things that happened to you that I'm aware of. I'll let Mr. Bartlome handle that if he knows something I don't know. So anyway, bottom line is, if that's what we're going to do, I will be happy to go back over it and do that. Then you have the 30 days to pay the $1,195 plus $2 processing fee. If you do that, I won't know you've done it. You've got to let your attorney know. He'll let me know. I'll confirm with probation. And then I will just send in an order that says alter and amend, waive Bexar County jail sentence, judgment satisfied. And you'll have no further involvement with this case. Is that what you want to do, Mr. Guerra Mendez?
Es que se cortó, lo más repíteme lo que dijo el juez porque se me fue la señal, pero yo no quiero ir a la cárcel, quiero pagar los 1,200, ¿es correcto?
Okay. Ed, I've got 30-day jurisdiction on this case. I'm just going to go back through what you and I understand Mr. Guerra Mendez requests are and sentence him and give him the 30 days to pay the money. And if that changes or something else comes up, we've got time to come back in and have another hearing if necessary. Will that work?
Just explain to him nice and slow that he needs to let me know when
entonces, ¿dónde los pago?
He can pay at 207 North Comal, which is a 4-story building across the street from the Bexar County Jail next to the parking garage. Cash, cashier's check, money order, or they may take a credit card.
Okay. ¿Comprende, señor?
Ok, no, si Dios quiere, yo la... Sí entendí. Ok, los pago en menos de 30 días.
And remember, you need, remember, Antonio, you need to tell me so that I can let the court know so that they can sign the order waiving and closing your case. You understand? Hello?
Perfecto, sí. Yo le aviso al abogado inmediatamente. Espero la próxima semana.
All right.
Okay.
Thank you. I appreciate it.
Back on the record on cause 642-530, State of Texas versus Juan A. Guerra Mendez on the motion to revoke community supervision. The court accepts the defendant's plea of true with an explanation. I grant the state's motion to revoke his probation. I sentence him to 6 months in the Bear County Jail, assess a $500 fine plus court costs, credit for time served, time and money to run concurrent. The defendant is ordered to report to the Bear County Jail to serve his sentence at 9:00 a.m. on October 26, 2021, which is a Monday. However, if he pays the adult probation department the $1,195 plus a $2 processing fee, before that time, I will waive his jail sentence. He will not have to go to jail. He will not have to report to the jail. His case will be over. So,
Ok, yo pago antes del 21 de octubre para no ir a la cárcel.
all right, perfect. Anything further from the state or the defense on Mr. Guerra Mendez?
Nothing further, Your Honor, on behalf of Mr. Garrett, Your Honor.
All right, good luck, Mr. Guerra Mendez. Thank you, Mr. Bartolome.
Judge, really quick,
Muchas
I'm not
gracias,
sure.
Dios los bendiga.
I'm not sure that the state gave a recommendation on the record.
Terminó.
So we would just agree with probation.
I'm
just
sorry,
wanted to clarify
did
that.
state, did I not ask for your recommendation?
There was so much back and forth, Judge. I don't believe that I stated
Let's
anything.
do it now. Before we vacate, state, do you have a recommendation on Mr. Guerra Mendez case?
Our recommendation is that we agree with probation, Your Honor.
Got it. Thank you very much. Anything further from the state or the defense on Mr. Guerra Mendez?
Not at this time, Your Honor. I believe we had an initial conversation which created the two options, Your Honor, about probation.
Good luck, Mr. Guerra Mendez. Thank you, Mr. Bartolome. Y'all are dismissed.
Thank you. Thank you, Ada.
Okay, this is.
Gracias, dígale al juez. Dios los bendiga.
Thank you.
Yes, thank you, sir.
Thank you. Thank you. Thank you, Judge.
You bet. This is cause number 660412, State of Texas versus Jacob Moya. And Mr. Moya is represented by Mr. Michael Bellevue. This is a motion to revoke community supervision. Mr. Moya and Mr. Bellevue, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that alleges to have both your signatures on it. In fact, is this your signature on this document, Mr. Moya?
Yes, sir.
And Mr. Bellevue, as attorney for Mr. Moya, is this also your signature on this document?
Yes, it is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Mr. Moya?
Yes, sir.
And Mr. Bellevue, as attorney for Mr. Moya, is this also your signature on this document?
Yes, Your Honor.
Representing the state, Mr. Guillermo Fletes and Ms. Megan Galloway. Representing the Bear County CSCD is Ms. Susan Gross, who I remind is still under oath. Mr. Bellevue, my understanding is this is an uncontested motion to revoke community supervision. Is that correct?
Well, as I said earlier, Judge, we wanted to go into a breakout room with you, or at least not be on YouTube, so I can explain a situation that occurred.
Is it something that shouldn't be public? Shouldn't be publicly? All right.
Yes, Judge.
Take a
I
break
believe.
and go in a breakout room, okay?
All right, thank you.
Okay. I believe what we're requesting is technically a chambers meeting, Your Honor, but it would just be in a virtual breakout room.
I've never been in a breakout room. I'm so excited.
Okay, go into 1.
I guess I don't need to go.
No, no,
I can stay here too as well, ma'am?
needs to go. No, you don't need to go, Mr. Jacobs, unless
Okay.
they ask for you.
Yes, ma'am.
Hey, Mikey, how you holding up over there?
Hanging in there.
Yep. You ready to go back?
Yeah, my brother, I just saw my brother yesterday. I hadn't seen him in 20 years.
Wow, that's awesome. So you
Yeah.
doing good?
Yeah. Had a good time yesterday.
Good. Is he older or younger?
He's a year older.
Okay.
Yeah.
Pat, is Joanne going to be the attorney on Jimmy?
Yes.
All right, because they're asking for documents.
Yes.
Okay, and now I know how to get in and out of a breakout room.
Very good.
Exciting stuff, huh, Judge?
Okay, back on the record on cause 660-412, State of Texas versus Jacob Moya. Mr. Moya and cause 660-412 on the motion to revoke community supervision. How do you plead, sir?
True with the explanation that you have.
Court
True
accepts
with you.
true with an explanation. Thank you. Ms. Gross, would you please advise the court and the parties of the status of Mr. Moya's probation, please?
Yes, Your Honor. Mr. Moya has failed to report for orientation. So he never signed his conditions and was last seen in court when he was placed on probation on July 22nd of 21. He has a balance of $1,151 on his fees, and he is delinquent $238 with no payments being made. We have no proof of his community service having been done, and he owes 36 hours. We have no proof of completion of a theft class. He has an extensive criminal history. The offenses in which he has been sentenced on have been possession of a controlled substance, penalty group 1, less than 1 gram, theft 2,500 to 30,000, fraudulent use, possession of ID, robbery, and he has a new case pending for failure to ID as a fugitive with intent to give false information, which I believe stemmed from the arrest on the motion to revoke. And this is his first violation, first MTR, and the probation department is recommending revocation.
And Mr. Bellevue, what are you requesting?
Your Honor, if possible, if the court is going to revoke Mr. Moya, then we would request time served And also, if possible, is the state willing to, if he's revoked, take into consideration his new case?
A complaint has not been formally filed in that case. I would be willing to TIC it, but I don't think I can do that unless there's an information filed. Is that, I can do it? Okay, then yes, that's fine.
It's just a different type of, it would be like you were dismissing a DWI that you couldn't do, that didn't have a file. It's the same thing.
Okay. Then, Your Honor, the state's recommendation would be to revoke Mr. Moya and that he receive a judgment satisfied and time and money to run concurrent and receive a credit for time that he's been in the Bexar County Jail. And as well, we would be taking into consideration cause number 669590.
Okay, so state you agree that if I decide to revoke Mr. Moya, I have your permission to take into consideration cost 669590. Is that correct?
That is correct, Your Honor.
Okay. Ms. Gross, what was the original fine amount on Mr. Moya's probation?
Judge, his original fine was $200.
Judge, can I speak by chance?
With your attorney's permission? Absolutely, sir.
Yes, sir.
All right, Jacob, go ahead.
All right, sir. I know that I didn't do any of my probation, and I know, I mean, it looks pretty bad on my end, but sir, if you could possibly give me one more chance. I did have 2 jobs, with the exception of whatever did happen that did put me in a traumatic, it put me in some time where I didn't know what to do. I was a little, I guess you could say, paranoid. My mom helped me to realize that not everybody was against me, because it was somebody that I trusted. But other than that, I was working and I am willing to pay back what I owe. I do know that I owe the person when this case had happened, the reason why I am on probation, and I'm willing to pay back the person. I'm willing to, if I could take classes for theft, if there's anything that could be overlooked, sir, or anything extra that could be added on, I will be willing to do it starting immediately, if anything tomorrow, sir.
Okay, anything further, Mr. Moya?
No, sir.
Mr. Bellevue, anything further?
No, Your Honor.
Mr. Moya, and cause 660412, the court accepts your plea of true with an explanation on the motion to revoke community supervision. I grant the state's motion to revoke your community supervision. I sentence you to 1 year in the Bexar County Jail, assess a $200 fine plus court costs, credit for time served, time and money to run concurrent, taking into consideration cost 669590, which is granted, and it shall be dismissed. Anything further from the state or the defense on Mr. Moya?
So what's gonna happen now, sir?
You stay in jail until the sheriff determines you finished your sentence, sir.
Yes, sir.
Anything from the defense?
Nothing further from the defense.
Anything further?
Nothing from the state.
Good luck, Mr. Moya. Thank you, Mr. Bellevue. Y'all are dismissed.
Thank you, Judge.